There we go. Good morning again, everybody. So great to see you all. Thank you for joining us from Brooklyn. Nice to see you guys this morning. And we're welcoming Binu again to talk to us today about transactions involving POAs and executors. Everything you need to know. It's one of those things we don't do terribly often, so it's almost kind of like a relearning of it each time we kind of step into it. So thank you, Binu, for joining us again. We really appreciate it.
No problem. Okay, good morning, everybody. So I was going to start, I think, with estates in general. That probably is a good place to start. And just kind of going through the process in terms of if you have a client who contacts you and sort of gives you sort of the typical scenario. And the typical scenario is, one of my parents or my parent has passed away, and what do we need to do? And the common situation that I've seen sort of more recently is a realtor might be the first person that an individual contacts, even before contacting a lawyer, as to sort of what to do with the process. Because now they have their parents home, they're not sure exactly what the process is, they definitely want to start the process of selling it, but they don't know any of the steps. And you might be in a situation where you're getting a lot of questions about how the process works, and it can be sort of overwhelming in terms of making sure that you're giving that client or clients the right advice. So I think generally speaking, the first thing that you might want to say to them or ask them is, have you spoken to a lawyer yet? And I think for most individuals, whether it's a small estate, whether it's a big estate, whether it seems like it's complicated or not at all, having an hour appointment with a lawyer makes sense. Because I think what ends up happening in a lot of situations is the major issue with estates is not necessarily the process, it is the interaction between typically the executors and the beneficiaries, and making sure that that process goes smoothly. And the number one issue that I see is everyone understanding the process and the time frame of how long things will take. Because that gives, that individual executor or group of executors, or maybe even the beneficiaries, a better understanding of sort of how that process works. And a realtor might be in a situation where, yes, you know sort of the process of selling this home, but you're now having to manage, all the time frames as well, and clients coming to you and saying, well, how come things aren't moving quicker? So I think in general, it's a good idea for a client to get some legal advice, but once again, obviously they'll still have, a lot of questions. Generally speaking, if you want to sell that property, you're going to have to go through the executor's going to have to go through the probate process. And I think that generally people might have an idea of what that is, but sometimes they might not. So I'm just going to kind of explain the two general situations. A person owns a property and dies without a will. That's the most complicated for, I think a lawyer or for an executor or for realtors, because you really can't do anything right away. There isn't really anything that you can do, because identifying who the possible executor of the estate is can be sometimes a complicated process. So you need to have that individual contact a lawyer and sort of have an explanation of how it's going to work. Some people have an idea that, I'm, the child who's here, I'm going to be my parent's executor, and it's not always as simple as that. Because you might have a situation where there's multiple siblings of that individual. They might all have equal rights to apply to be the executor, and then there's that interaction with all of the sort of family conflicts and family issues that sometimes come up that sort of need to be addressed right away. So an individual dying without a will can sometimes be, the most complicated process. Obviously, they need to get advice. If an individual comes to you and says, my parents passed away and they have a will, and it does indicate that that individual is the executor, then there's some things that can be done, but we're not going to be able to finish the whole process until probate's completed. So a realtor could identify, okay, this is the individual's the executor, this is their will, this is their, the death certificate, take copies of that. But it's really important to understand that there could be a lot of issues that come up. An individual hands you a will and you assume it's the person who passed away, the testator's last will and testament. But you don't know if that is that document or not. So that individual could have revoked that will, made a new will, there could be multiple copies of wills. So it's important to understand, okay, let's not jump the gun. Let's not start the process until we have a really firm understanding of not only is this the last will and testament, but also understanding the family composition as well. So that's understanding who the individuals are makes it a little bit easier to sort of identify and address, okay, does this look like it's going to be a complicated process or not? Is everybody on the same page? Are there any of those conflicts? Because you could have a situation where you start the process of, okay, I know my client's eventually going to get probate, let's list the property. They seem very eager about getting that started. But then you start that process and then there might be some bumps in the road. The person that you're getting instructions from might not be the person that you need to get instructions from. So it can get overly complicated. But let's just assume, for this scenario that you sort of identify that there isn't any family conflicts, there are no real issues, and you have a will, it names an executor, or let's say 2 executors, and everybody's sort of working together. The probate process and sort of understanding that is, I think, important because people generally just say, okay, I know I have to get probate, but exactly what is that? And really what it is it's the court's approval of the appointment of an executor. And you might think that that will names the executor, that seems to be pretty cut and dry. But what the court is wanting is they want the will, the original will, to be deposited with the court and an application to be issued in which it identifies any potential issues or conflicts or errors or omissions in the drafting and the execution of the will. And if there are none of those issues, the court will then issue a certificate of appointment. Document sealed by the court, signed by the registrar, that now allows the executor to handle all of the assets, debts, and issues with respect to the individual's estate. And that process is not overly complicated, but it is sometimes time-consuming. So if an individual comes to my office and says, okay, we want to start the probate process, you have maybe 2 or 3 weeks if they're really, really good at information gathering to allow us to get the application put before the courts. And then once the application's before the court, probably a 3 or 4 month process before a judge actually gets to see the application and all the associated documents, identify if there's any issues, and then issue that certificate. So for a real estate transaction, if you have a circumstance in which an individual is very eager to get a property listed and an offer is accepted, and you're waiting for the probate process, everybody understanding that it is a process, the court is now involved. We don't have any control over when or if a certificate of appointment is issued, then everybody needs to sort of be patient about the end of that process. So you have, a signed offer. The agreement of purchase and sale has to contemplate that we don't have the legal authority to transfer this property to the third party purchaser. So if we don't have the legal authority to transfer that property, we need to wait for it. The offer needs to be typically conditional on having that certificate of appointment issued. It allows the estate to get out of the deal if there's some issue that occurs that makes it impossible or delays the issuance of that certificate. A court challenge and notice of objection being filed with the court to stop that process. So in the end of the day, it allows the estate to sort of get out of that agreement of purchase and sale. Typically sort of a secondary clause, a companion clause is in there is a clause that helps to sort of push the closing date, whether it makes it earlier or later, and allows the estate to change that date depending on the issuance of that certificate of appointment. So sometimes you have those clauses sort of working together, allowing the estate to get out of a situation in which they're legally obligated to sell the property, and then obviously the flexibility to change the closing date if necessary. You also have a situation just with a certificate of appointment hasn't been issued yet, in which it might limit the number of interested parties with respect to the property. Individuals who are sort of purchasers, projected potential purchasers might look at it and say, well, if you don't have a certificate of appointment, I may not be willing to wait all of the time to basically, have that completed. Some individuals might be in past, they've been actually very, accommodating in terms of waiting because of, sort of the market, but it really depends on the circumstances. So obviously, understanding how long that process is important. Understanding it, I think, just for everybody in general, that there is sort of this general idea out there, and I don't know exactly how it came about, that people will say to me, I read or somebody told me that an estate will be wrapped up within 6 months or a year, and I don't know why things are taking so long. I mean, it's just almost impossible for an estate to be done within a year's period. But I hear it often. So for a client who's selling a home, they just have to sort of understand that it is a longer process. There could be, bumps along the road, and having a lawyer deal with it and sort of managing those expectations also, helps as well.
Can I ask you a question about the timeframe, just to clarify? So because there can be all kinds of issues up front or leading up to, but at the point where the lawyer makes the application to the court, can you speak to what you're seeing in terms of general timeframes for the certificate of appointment to be issued in the Durham area?
Yeah, I would say about 3 or 4 months.
Okay, from that stage.
With no issues. I mean, every jurisdiction is different.
Right.
There are situations in which, like let's say we applied in Walkerton, and within a month we have an issued certificate. And easier processes there. You can contact the court in Walkerton. They'll communicate with you. They'll tell you, okay, maybe there was a deficiency. Can you just provide me this information? But if you're applying in Toronto, you're going to get a complete black hole of information. You're not going to have the ability to call anyone, email anyone, get updates about anything. So it's different situations depending on different jurisdictions. And sometimes the issuance of certificate can be rushed in urgent situations, depending on if there's an imminent closing date. So if you have an agreement of purchase and sale, you can provide it to the court and say, we have a closing date, it's an urgent. But once again, in Toronto, Newmarket, Brampton, you're probably not going to get a judge to look at that. In Bracebridge, maybe you'll get an answer, and you might get that certificate issued. I mean, we've had situations like that in which an individual had sold a property, in anticipation of the agreement of purchase, the application and the certificate of appointment. And it wasn't an agent in this office, it was an agent in another office, not a Sutton office, drafted an agreement of purchase and sale without that conditional clause. And we were running around at the last possible minute, trying to contact somebody in Toronto to get a certificate of appointment issued. Luckily, we found somebody. She answered our email. She was, I don't know, she was kind of not nice to us, but she still issued a certificate. And then told us to forget that we ever had her email address. So.
What is it again?
Yeah, so basically don't email her again or whatever. But so the situation is we were rushing and sort of panicking. We had a client who didn't have any outs. We had a purchaser saying we need to close, and all of the circumstances that sort of come from that. And it really it started with the client communicating something to the agent, them going off and doing whatever they wanted to do, and then coming to us and saying, this is what we did. This is the pie we baked, can you deal with it? And that was basically, where we were kind of stuck to try to solve that problem.
Interesting, both sides, neither side had put that in, like even if you're bringing in and didn't have a condition to the seller, like one side put a clause in there, so that's interesting, both sides.
Yeah, and I think that it's a situation where if you have two individuals who don't know and are willing to ask, then they're gonna make a mistake.
Yeah.
They're just going to assume that it's fine and it looks like a good offer, it looks like it has all of the right clauses, seems like we're on the right page, but not understanding exactly what the process is, where we are in the process, that's a huge issue. So, jumping the gun,
Yeah.
without understanding that is then where everybody is scrambling at the last possible moment.
I have a question. What if there's a mortgage on the property during probate? Like, does it still need to be paid if they don't? Does the executor need to pay that, I guess, if there's an account? Like, what if the money's not there?
I think it depends on the financial institution.
Okay.
In most cases, I would say if an executor contacts the bank, says, here's a will, here's a death certificate, this is the circumstance, gives them an idea that a solicitor is dealing with, they will make an amount, they will typically hold off for a period of time. But that has to be clearly communicated to the bank, and you need to get the information back that they are not collecting the payment. Because I just had a situation with an estate in which it was an application without a will. I indicated to the executor, you need to contact the bank and tell them, this is the circumstance, we're applying, this is the time frame, and the client spoke to somebody at the branch level, didn't get any confirmation that they ever talked to anybody, higher than at the branch level, and then received a letter in the mail addressed to the individual who had passed, saying, we've now passed it on to a lawyer, it's in collections, they're gonna start the power of sale. Now, there's a solution to it. They contact me, they're in a panic, we contact that solicitor, we explain to them the situation, they put everything on hold, so there's a solution to it. But obviously, the levels of communication have to go there, the confirmation of what's happening takes place. Now, there's also situations where I've seen where banks, where let's say an individual is, banking in the same financial institution that they have their mortgage, let's say it's Scotiabank. And the bank will just say, well, we'll just keep taking the mortgage payment out of that individual's account. And that's basically it. So that's nice and simple, easy, it's straightforward, as long as that individual who passed has enough of the account. But otherwise, it could be a situation where, an executor is going to have to dig into their pockets, pay expenses for the home, maybe it's not just the mortgage, maybe utilities or any other expenses, maintenance of the property, so during the period of time in which you're applying for probate and maybe, until the property is sold, keep accurate records and get reimbursed for the estate when necessary. But I'd say generally banks understand those situations, but you have to get confirmation from them. If you don't, then the panic starts to set in. And once it goes to the level of the lawyer getting involved on the collection side of things, now you have additional costs. As soon as it gets to a lawyer, you're adding a couple $1,000s to the amount that you have to pay to discharge that mortgage. So you have to make sure that those issues are clearly addressed.
What determines the jurisdiction and where you get your probate?
Jurisdiction is based on where the individual's last fixed place of abode was, so where they typically lived prior to passing. There's certain situations where we might have an individual, let's say they lived in Durham, they have a property in Ajax, and they're very sick and they moved with their parents, they moved to their child's home in Toronto for a couple of weeks and then they pass away. It would still be typically Durham, where they had their home. So it's really where they have the property in which they live. Okay, so in terms of sort of explaining the probate process, I think I've sort of gone through that, the length of the process. The other issue that I constantly hear is people say to me, well, I heard that you can sell this property without getting probate. And there are situations where that could happen. You might have an individual who's passed who jointly owns a property with their child or children. I never recommend situations in which that takes place prior to the person passing. It's open to a lot of issues, lots of conflict. I have a lot of elderly clients coming to me saying, somebody at the bank, my friend, my dentist told me, put my child on title. I typically will say to them, don't do that. Here's the reasons. And most of the time they understand and understand sort of what the alternatives are. They typically want to do that to save administration tax, but they're not really saving that much and opening the estate up to a lot of issues. But if you have a situation where, let's say there's one child, one parent, there's no other children, and they are both on title, yes, you can now sell the property, register a survivorship application, removing the deceased person from title, and the person who is remaining on title can now sell the property. Okay, that's a pretty straightforward process. There's a second sort of issue that comes up. It's more complicated. It's called the first dealings exemption. And I would say, generally speaking, as time goes on, it becomes less and less available to individuals. And it gets complex, so I know maybe some of what I'm going to say is going to be complicated, but maybe you can watch the video afterwards if you have that issue. So when properties in Ontario were transferred from the registry system to the land title system, there was a conversion of those properties by Ontario. So all properties in Ontario were in the registry system. They created the land title system to try to solve all of the sort of minor issues with adverse possession and minor disputes in terms of boundaries by transferring the properties to land titles. So when they did these conversions, they gave properties typically two types of qualifiers. They transferred a property and then they said, you're in land titles and your fee simple absolute. That means that there are no issues with the property's title. It's been transferred over, you haven't determined that there's any issues. The second part is if they converted the property to land titles conversion qualifier. The parcel abstract, it will say LTCQ. And that means there is some issue that Terraview has identified that means the property cannot be fully converted to the land title system. So it has 1 foot in the land title system, 1 foot in the registry system. For those properties that have qualifiers, there's an exception to the rule, an exemption, that allows for individuals to avoid the probate process, to sell the property because it still has some dealings with the old registry system. And in the old registry system, you could sell the property without getting probate, so they have that. Now, the exception or the issue there is you can't have ever transferred that property after the conversion. So once the property's been converted, if there is a transfer subsequent to that, no exception to the rule. So typically what I'll see is somebody who purchased a property in 1950, they were in the registry system, property is converted, and it has that land titles qualifier, and they've really never done anything with it. There's no transfers, there's maybe no registrations at all. And in those very, very narrow circumstances, and there's more, but in those narrow circumstances, you can avoid the probate process. But it doesn't necessarily mean that that estate can avoid the probate process entirely, because there may be other assets that the individual has, investments, bank accounts, or other assets that the probate process is necessary for. So you might be able to sell the property without probate, avoid some of the estate administration tax, but it doesn't necessarily mean that the state can avoid probate completely. So it's just sort of important to understand that. And I just wanted to talk just very briefly about powers of attorney. They're a little bit more straightforward, but the main issue or the main issue to identify here is that we have a lot of issues. If you take it in terms of an individual who's completely incapacitated, it's very easy to identify that a power of attorney needs to be used in those situations if their attorney needs to sell their property or do anything with their property. But you have situations in which the capacity of that individual is maybe questionable. Or it could be a situation in which that sort of has to be determined. Once again, having the attorney meet with a lawyer and sort of determine what those capacity issues are really, I think, important. And even if you sell the property under a power of attorney, the purchasers are going to want to have information about they're gonna wanna have information about the use of that power of attorney. They're gonna want to know why it's been used for their title insurance policy, their title insurance company. And so having an individual meet with a lawyer and sort of identify if there are any of those issues sort of makes sense, because there's gonna be some questions prior to a closing of the transaction about the use of that power of attorney, and you really have to make sure that that is a proper use of the power of attorney. It's also a situation where, you know, as a realtor, you just have sort of can't assume that an individual hands you a power of attorney, and it's as simple as saying, okay, well, that person's named in the document, and we can start the process of selling an individual's home. It's not as simple as that. So it's important to identify if there's any sort of specific issues with the use of that power of attorney, and sometimes talking to the grantor of that power of attorney is also a good first step. I think a lot of people sort of maybe avoid that. They feel like, if the person named is coming to me and saying this is what they want to do, it's okay to take a step back and say, okay, the grantor of this power of attorney, who are they? What's their situation? Maybe I need to have a quick talk with them to see what the situation is, or identify maybe it's impossible to talk to them and what the issues are there before taking any action. Because sometimes individuals will act on a power of attorney in rare circumstances without the grantor's knowledge, without their approval, and sort of in conflict with what the grantor's wishes are.
Okay, do we have, there is a question actually in the chat. Nadine, you can unmute and,
Okay, hi guys.
morning.
Good morning. So it's about the EAT, Binu. Like I'm pretty sure a bunch of us have clients that ask us the benefits of going through getting the certificate of appointment or listing before that, because obviously the asset is valued and there's that 1.5% EAT that they pay. And I was asked by someone, because of the downward transitioning market, their estate, let's say, was assessed at $800,000, but it's going to now come to market, certificate of appointment is complete. And let's say it only sells for like 750, or let's say 700. I've heard that it's almost impossible to get a refund of the EAT. And then on the opposite side of that as well, what is the difference? So if we go through the certificate of appointment and it's bang on, fantastic. Let's say we go through the certificate of appointment, but we undervalued by 200,000. I've heard that tax, that difference that you have to claim afterwards, is taxed more than the 1.5. So I guess my question is, if someone was to ask that question, obviously I know it's out of my area of expertise, they have to talk to an accountant or a lawyer, but I would like to kind of know, based on the values changing, what you think about that as far as how it's taxed.
Well, in terms of what we're talking about in terms of valuation date, you're talking about the date of death for that individual.
Yes.
There can be dramatic changes in the value of that property between the date of death and when the property is sold. Prior to the current market, we saw situations where people were considerably higher, and they paid the tax based on 1.5% on the date of the individual's passing. And I guess in their minds they had a windfall at that point. Now we have situations where there could be adjustments where that value is lower. The only way to sort of, maybe, I don't know if the situation is to sort of challenge that, is to have some type of valuation as of the date of death that says that the value was sort of misestimated. It was a situation where we used a value that we shouldn't have. But typically for us, we ask for appraisal or a letter of opinion before we put that in the application. So you might have a situation where an application was made without that evidence, and then you go and get that evidence, and then when you're doing the estate information return, a second phase in the estate that reconciles the estate administration tax that you're going to be paying, then you can say, okay, you know what, I have the evidence now, this is what the correct value is, this is what now is the correct value of the estate, this is the correct tax, we paid too much, we want to have some of that tax amount back. Difficult to do sometimes in those cases. It might be a situation where the estate sort of has to accept the fact that those values changed and pay the tax based on it. I think most executors would probably look at the 1.5% unless it was so different between the value on the date of death and the value on the time of the property was sold, that they'll just have to just sort of deal with it and accept it.
Okay, so I understand that if, so the 1.5 of the EAT that's charged, if it's different and we sell the house for $200,000 more, there's nothing there that they have to claim. There's no increased amount of tax that they have to pay. So that's what you mean by the benefit, right?
Yeah, that's exactly right.
Okay.
May I
Thank
follow up with Nadine's question though, and just an example, so not where there was error made, but let's say date of death was March or end of February this past year, now probate's just come to fruition. We have a dramatic shift in values. So the estate would have paid the 1.5 on, let's say, 1.6, but at point of sale, that property's selling for 1.2.
Yeah, you're paying on the date of death.
So regardless.
Yeah.
But you're also getting more money for that sale too, so you're getting 400,000 more.
No, I said the reverse.
No, I know, but I'm just saying that, okay, I see, yeah.
Right?
Yep,
It's just you have to get the valuation of this date, because it was date of death.
Yeah.
But the estate isn't realizing the benefit of that till now, and that is a $400,000
Difference,
I mean, we saw, I've had estates where, you know, there was large periods of time between the time when the individual passed and the property was actually sold. The executor just sort of decided not to deal with it, and, you know, 6-7 years passed. And, you know, having those discussions with the executor about, you know, what the differences are, before it was a positive discussion. And then now it could be a situation where it's like, okay, you know, but if you think about 1.5% of the difference, you sort of have to think about, you know, whether it's worthwhile to even spend a lot of time to, you know, sort of, are you getting back maybe $500 or $1,000 in the grand scheme of a $1 million or $2 million estate, but because it depends on the circumstances.
And Binu, so that going to that question, so I have an estate that's being sold about 5 years after the death, and the estate's going from a parent to a child. That increased in value, is that a taxable income? And then would that be to the children? Is that how that works, or to the estate?
Yeah, well, that's an accounting question, but I would
Okay.
assume there's gonna probably be capital gains from the time that the individual passed, that it's gonna be payable by the estate. Because it, you know, you can avoid at this point, if it's a principal residence, paying any capital gains. But obviously when the individual passes, it's a different situation. So
Okay.
talking
Thank
to
you.
an accountant about that is a good idea, because there could be ways of reducing and deferring some of those taxes.
Anybody else joining us? I have a couple of questions, things that kind of come up frequently, just from the actual paperwork, transaction side of things, is we get asked a lot when there is either an executor or a power of attorney, how the actual signing is done, in terms of who's signing, what statements are being made with such signatures. Can you just speak to that a little bit?
Yeah, so if you're in a estate, you know, let's say it's the seller is going to be the estate of the deceased individual. Let's say there's one executor, they're going to be signing their name. You're going to write underneath, maybe in you know, very neatly, just say you're executor for the estate of, nice and simple that way. So it's that individual signing. For a power of attorney, same situation. It's the individual signing. Typically, you would say in the seller area there, you know, by power of attorney. And then in the signing spot, this individual who is the attorney would sign and just say power of attorney for the individual who's granted the power of attorney.
The other complicated piece of it for people is the FIN track. ID forms. Who needs to be fin tracked? I mean, the estate's gonna be pretty obvious, but in a power of attorney, the identification, who's being identified, and what role, is there a third party?
Yeah, so I mean, the situation obviously is that when a power of attorney is used, I think you have to be very careful about, who the client is in that situation. Because technically speaking, in all of these situations, with an estate or with a power of attorney, your client is the executor and the individual who's the attorney. And identifying that as the situation also helps to understand sort of what your role and responsibility is. When they say, are you the estate lawyer? I'm not the estate lawyer, I'm the lawyer for the executor of the estate. I'm the attorney, I'm the lawyer for the attorney who's been granted that power of attorney. Now, do I have obligations to the estate? Do I have obligations to, the grantor of the power of attorney? Absolutely. But understanding, who the client is in that situation is important. Because obviously in the grand scheme of things, they're gonna have access to that money, and that's what the government is interested in.
Right.
They're interested in where that money is going, money laundering reasons and otherwise. So that's understanding exactly who your client is on the real side of things, the legal side of things is important. So there's some trust obligations for the grantor and the estate, but your client is the individual who's been granted it.
The guidance we've kind of been given in the past around those was if you're an executor or if you have power of attorney for someone else, you are the one that has been tracked. We take ID, they are the client, and the third party is the estate of, in the case of a death, or the individual who has granted the power of attorney to someone else, correct?
That's exactly right.
Yeah, it's a little, as I say, because we don't typically do these, not on a daily basis, you can kind of forget sometimes how that's supposed to roll, so. Okay. Thank you. Anybody else have any questions? Anybody joining us via Zoom? You guys got any questions for Binu around this? Any complicated situations you've encountered that you wanted a little bit of guidance on? No, anybody here?
I was gonna say, you answered my question on land titles, because we were told that a cottage that was under land titles and was actually their primary residence didn't have to go to probate, and that was the first time we had heard about that, so we have that situation, 5 kids coming up eventually with our cottage, so it's just, I'll have to look up and see if it's got any attachment, as you said, was it all,
So what you look at is typically for us, we pull the parcel abstract.
right?
Right on the left-hand side.
Yep.
It will say either fee simple absolute.
Okay.
Or it's gonna say land titles conversion qualified. So if it is LTCQ, that's the first step in saying, okay, there's a possibility
Good.
that we can avoid probate in that situation. And there's a couple of other steps in
Sure.
the analysis. But if it says fee simple absolute, don't even think about it.
Beauty.
It's not gonna help you.
Yeah.
Is there a certain amount that an estate has to be worth for it not to go to probate? So less than a certain amount?
Yeah, so typically, it depends on what the assets of the estate are. So if you have an estate that's less than $50,000, but the assets are, let's say, just all banking assets, then typically banks will have a very, I wouldn't say it's streamlined, but like an in-house process to basically deal with those estates. The executor would basically sign declarations that say, okay, let's say that all the debts of this individual will pay, the estate is less than $50,000, I'm absolving the bank of releasing the funds. If you have a situation in which that takes place, yeah, maybe you could be able to avoid probate. And now we have sort of 2 systems in Ontario. We have a small estate certificate, which they say is an easier process for estates up until 150,000, which in my opinion is exactly the same paperwork for the most part. And then they have for estates over 150,000. But for our context, if an individual owns a home, you're probably in a situation where you're not going to be able to avoid it. It's not going to reach. It's obviously going to be higher than 50,000.
50,000 is the benchmark number. If you're a
It's likely, yeah.
One other scenario I remember an agent bringing up to me, they were listing a property with the power of attorney. And partway through the selling process, the individual passed away. And that was a bit of an education because you need to correct me if I'm wrong here, but my understanding was at the time of death, the power of attorney no longer exists, that ends at that point.
I mean, we had that situation a few years ago, where an individual elderly mother who knew that sort of she was in her last days, sold the property under power of attorney, got to the closing date, it was a Friday, contacted us on the Thursday, it says she's passed away. So we had 1 day. Luckily, we had the first dealings exemption, we had an opportunity to use that for that property, so we were able to close on the Friday, but as soon as that individual passed away, yes, it becomes an estate now. The power of attorney, it's not valid. The individual doesn't have legal authority to sign those closing documents, and we can't register that transfer. So the lawyers will have to get involved, extend the deal, and determine sort of what the legal and financial ramifications for both of the parties are. It's rare, but it happens.
If let's say in that situation, if the power of attorney, the same guy as the executor, cannot continue, still that's.
Well, it can continue, but you're gonna have to wait until you get that certificate of compliance.
Everything gets frozen the second that person passes away.
So now, because you could have situations where those people are different.
Yeah.
So you have now, conflict at that point.
Yeah.
And now you're dealing with different individuals.
I never even thought of that. If you have someone who's got power of attorney and has sold legitimately the property on the individual's behalf, but it hasn't closed yet, the person passes away, and then you've got a different executor who, wow, that, I don't even.
They've run into that situation twice.
The situation can happen, and it really,
So,
yeah, it depends on like sort of sometimes geography. So an individual might say, okay, I want my daughter who's living near me to be my power of attorney.
Right.
And then says, oh, I want my daughter and son to be my executors of the estate together.
Right.
And then all of a sudden now, that individual's still part of it, the daughter's still part of it, but now, the son is now involved as well. So it gets complicated.
Very good.
Yeah, absolutely. I advise clients to avoid those situations, but I will tell you, they don't listen.
they don't listen.
They are insistent that they know better, and so I give them all of the options, we go through it, and they say, okay, no, it'll be fine. And then we have executors coming to us and going, okay, we've been left with a huge problem, what do we do? And have to help them through that process, but it can get complicated.
Years ago, a lawyer said to us, if you have any enemies, make them an executor.
No, I don't think I've had anyone who's been an executor who's enjoyed the process.
You only do it once.
Yeah.
They absolutely hate it. They don't want to be involved. It's not a task for the lighthearted, and it just continues on and on and on, and it's quite stressful. But we all have to do it, maybe at some point, your parents or otherwise. So it's good to get good advice, and then there you go. It's a very long, painstaking process. And when I go through the scenario and the process to executors during that first meeting, I mean, most of them are pretty dumbfounded about what they need to do. So.
We just went through that with co-executors, and it's not much fun either with two of them. It's in our own family, we went through that.
Yeah,
It's not.
I highly recommend people not pick two executors, but it's not really my say.
Mm-hmm.
There's a lot of people who say, okay, I have 2 children, 3 children, I want them all be treated equal. It's a recipe for disaster, it really is. It's even clients are thinking, you know what, children get along wonderfully. They are going to be able to figure it out and it will be great. It's not.
Somebody once told me the worst parts of every human come out when dealing with the death
than the will of family members, right?
Yeah, so what you've done is you have a situation where typically, let's say a parent has passed away, this person's emotional, their whole family is emotional, and now you said to them, here's all this legal and financial work that you have. And you expect them to rationally go through everything and sort through everything. No, it's gonna be sort of the powder keg of conflict. So even two people who get along wonderfully, will, now have to, do math together and do legal work together. And it's not going to always work out so well. And so you have to be very careful. An individual executor can sort of move the process forward quickly. And really the only issue is if they're negligent or fraudulent in some way. And they can move it to its ultimate goal. Two individuals, they can have a difference of opinion on everything. And then you're years later.
Is there a company that would be, like, can you hire, like, can you have your lawyer, the executor?
I mean, I don't recommend a lawyer as an executor. I mean, and that was sort of.
Somebody that's not.
Don't ask him.
Binu knows what's involved, I don't want to do it.
Well, it's not even just that, it was a very old school way of dealing with things. Where individuals would say, okay, I'm gonna name my solicitor as the executor. If we're talking about conflicts, let's just open everything up for a conflict right now. An individual doesn't know anything about the family, is now in control of everything, and is now sort of piecing things out to her. And obviously, a lawyer, they pay their fees, their executive fees, all of that, issues that are there. And if we're talking about, I don't have anyone I trust to do it, then you can go to a financial institution, let's say it's Royal Bank. They have a separate sort of subsidiary, that will deal with it. Now, if you want to do that, you can't just sort of snap your fingers and have that happen. You go into the bank, you talk to somebody, there are documents that you need to sign with them, approving the fee schedule that they will charge, and all of the expenses that they have. And then they will have specific clauses the lawyer needs to include in the will that allows them to take their fees on a periodic basis and deal with everything with respect to the individual's estate. So if you don't have anyone you trust, you can appoint a trust company, let's say, but there's a process of sign the documentation, have the lawyer draft it. They typically want to approve it before it's signed, and then away they go. If you don't go through that entire process, that trust company might say, we don't want to get involved. And they'll just basically renounce their rights. So it's a process, but it can happen.
It's interesting you mentioned about parents leaving, like putting children on title. My mom keeps on insisting, because her hairdresser told her, that to put the five of us, not just that, she's had other people tell her and friends, to put the five of us on title at the cottage with her. And we just keep saying, Mom, no, it's easier. Leave it to the five of us, let us figure it out at that end. But she keeps on insisting, so now she's kind of listening to us and hasn't done anything, but she keeps bringing that up.
It's this idea of saving 1.5%.
Yeah.
And what you open it up to is, let's say with 5 siblings, I'm sure all of them get along.
Oh, yeah, we do.
All of the conflicts, not only that, I mean, if one of you had a situation where you went bankrupt.
Yeah.
What's the legal ramifications for that? A trustee in bankruptcy is now involved in that property, didn't want that.
Yeah.
Let's say you have matrimonial issues, and now you're entitled to a property with all of these individuals, and what's the legal authority to deal with that property in the midst of a separation and divorce process?
And does capital gains come into effect for all five of us if we have part of our own house and then part of the cottage?
Yeah.
Yes, so that's what I keep telling my mom. She doesn't understand, but I keep saying, Mom, there's tax implications to all five of us in that case, so leave it. And it's a principal residence, actually.
It's the typical issue of a very complex problem, and people only understand the very simplest solution to it, and they don't understand all of the ramifications of it. And I know what it is. It's because it's tax and it's taxation. If you say, I want to save the tax, why am I giving that to the government? I completely understand it. But all of the other issues that come up. And if you did the analysis of what you're going to pay maybe in capital gains versus estate administration tax, it might be a losing proposition. So we've had those situations where we know an individual's, let's say, terminal, they're going to pass away right away. Maybe that's the only exception to the rule that I would sort of run in my office, because we know sort of this is what the inevitability is. But otherwise, it's a bad idea.
Okay, well, I don't know, I'm not sure how to tell. We have an LGBTQ, property,
Oh,
but.
Yeah, I mean, there's always exceptions, but the question obviously is just generally, I think I persuaded almost every single one of those
Good,
clients.
yeah, so I'm telling my mom.
I had a client that was terminal and she sold it and right before she died and her parents took the cash, like, so they were able to not pay capital gains, because they would just basically put it in her account. Once she got the money, it closed, she gave it to their account, and then she passed it.
Yeah, so if you have a situation where an individual is terminal, hopefully it's not the case, but, and you know they're gonna pass within a few months, I mean, there's not gonna be any capital gains. You know, for the time of that transfer until the time of the sale of the property is a very short period of time, probably not a huge difference, probably no gain, you can save that issue. But if you're doing it as sort of an estate planning tool for 10 years down the road, it just doesn't make any sense.
And I will apologize if I'm repeating somebody's question, I was half listening and responding to an agent. An executor, before the certificate of appointment is issued, there is a number of fees, there will be a number of different expenses incurred in order to maintain the property. I mean, there's still going to be utility bills, those kinds of things. In a very short, concise way, is there a way, is that an out-of-pocket expense initially for the named executor who then basically keeps everything and then the estate sort of balances it, or is
Yes.
that, yes?
So there are a wide variety of sort of ways to deal with it. But if you're talking about an individual, all their assets are frozen, they're not joint with anyone else when they're passed.
Right.
And you can't get access to those funds.
Right.
But as an executive, you can sometimes, at the discretion of the bank, ask for them to access the individual's funds to pay legal fees and estate administration tax. And usually you need a lawyer's letter to sort of access that.
Right.
Other than that, if everything's frozen, you're dipping into your own pocket to pay that. So it can be complicated. Now, a little bit of planning. If you want to say, okay, I know my executors are gonna have this expense and they're not gonna have access to those funds, which I can remember. Some people say, okay, we'll put up a joint bank account, put a little bit of money in there.
Right.
You know, estimate, okay, what are my costs going to be? Joint with my executor, if they can access those funds, they'll reconcile that at the end of the day.
Right.
They have access to it. Some people use life insurance as well to do that as well, you know, in terms of getting access to some funds as well. Executors who don't have access to funds, typically I'll say to them, okay, this is what we have in terms of expenses before you get that certificate of appointment, and they are racking their brains to figure out how are they going to come up with that. You know, it's
So that's a great estate planning tip, and even just a separately, a joint bank account specifically for that.
Yeah, it doesn't have to be to all of the funds that you
Sure,
have.
yeah.
Just go to the bank, say, there's a small account, you're putting $20,000 in there. It at least gives a little bit of a buffer for the estate and the executor to pay expenses. You know, and just make sure that things aren't going into arrears. There's always a solution to it, but it does help to alleviate some of those.
You know, I'm joint account on all of my mom's accounts, but I'm not executor. Is that an issue or no?
I mean, it's.
Should it be the executor has that access, or I can give it to the executor if there's funds?
Well, I mean, technically speaking, you have access to the funds on one side, but it is your mother's funds for the entire estate.
Right.
So if she passes, you can access those funds,
Mhm.
but once again, you're keeping accurate
Yeah, so
records of what you're
definitely.
using.
Yeah.
Providing that to the executor, because that's going to be
Okay.
eventually
Perfect.
to be split.
We ran into that situation, my mother-in-law passed and my wife was the executor. We applied for, against her account, to pay for funeral costs, to pay, any other subsidiary bills. They were very open to it. And they released, I think it was close to $18,000. But we had to show bills for that, like we had to show that, the funeral cost was this, and that cost was that, and what,
Yeah.
I should say they gave us access to certain amount, they didn't give us the money, they basically said get access to this amount, percentage of money.
Yeah, and some of those, the financial institution will just make the drafts payable to the minister of finance or the funeral,
Yeah.
whatever.
Yeah, they did,
Right.
they
Directly,
did
so-
exactly that.
Yeah, so they don't have.
Yeah, so they, but they were very open, it wasn't something that we had to calendar or whatever. We had access to that, like, or she did.
Yeah, I never say yes or no with banks, just
Yeah.
because even if they say yes, you know, it's a process.
Yeah.
Sometimes it can be a long process, so.
Yeah.
Obviously, the situation is the bank might say yes, 2 or 3 months down the road, and then you have the state is like, okay, well, we wanna get things moving, so.
Yeah.
It's a yes with qualifiers.
Sounds like it's a very big responsibility and a
Yeah.
very time-consuming endeavor to be named the executive.
Estates are not simple. If you look at the checklist of the things that you're gonna be doing as an executor, it's branches everywhere.
Right.
And keeping everybody apprised of what's going on, being on top of everything, it's complicated. And you're gonna have somebody in your beneficiary saying, what are you doing? Why is it taking so long? You're not doing the right job. And, you know, you have to manage those expectations early on. So how that process is
Did anybody have any more questions before we let Binu go? Our 30 minutes to thrive is 59 minutes to thrive today, so. All right, well, I just want to thank Binu very, very much.
Something came up there.
Oh, is there?
Does it make
Oh,
sense?
there we go, Sherry. Does it make sense if you're able to pay all the costs out of pocket associated with a property upon a death and then bill the estate later?
Yeah, so I mean, yeah, you can get reimbursed later on, it's just, yeah.
Okay. All right, well, thank you again, Binu. Always great information for us and a good refresher, because it isn't something that we tackle sort of once a week here, so. Thanks again, everybody, for joining us via Zoom as well. Really nice to see you. And have a good rest of your week. It's Thursday already.
Yeah.
Okay. Thanks again, everybody. Thank you, Binu.
Thank you, it's good information.